From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Maine becomes the second state to remove Donald Trump from the 2024 primary ballot under the 14th Amendment. Plus, the House passes a bill to tighten transparency rules on foreign funding to U.S. colleges and universities. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Bill McGurn and Kim Strassel. The 14th Amendment was passed after the Civil War and includes Section 3 that was intended to stop Confederates who, quote, engaged in insurrection from retaking posts in the federal government or the state government. And the big political news last week was a second state has now applied that to Donald Trump and the January 6, 2021 riot. That is the state of Maine. And Secretary of State Shenna Bellows, in an administrative ruling, here she is on a local CBS affiliate explaining where this issue goes now and why she made this decision.
Maine law requires me to issue a decision. Then any of the parties, and in this case, Mr. Trump, have 5 days to go to Superior Court. I stayed the effect of my decision, so nothing happens until the court makes a final ruling. If they can also have the right to appeal after Superior Court to the Maine Supreme Judicial Court and to the U.S. Supreme Court. So this is how the process works here in the state. I swore an oath to uphold the Constitution, and I fulfilled my duty. I reviewed the evidence, and in my view, the weight of the evidence made clear that January 6, 2021 was an insurrection and that Mr. Trump engaged in that insurrection in violation of Section 3 of the 14th Amendment to the Constitution.
Bill, what do you make of this decision? We are now 2 weeks from the voting beginning in the 2024 primaries with the Iowa caucus. And to my eye, this could be a big in-kind donation to the Trump reelection campaign.
Well, that's what our editorial said, and I think it's right. There seems to be this perverse competition among Democratic Party officials and prosecutors and so forth to use or abuse, I would say, their powers to try to get Trump off the ballot, either by prosecuting him or, in this case, by highly selective readings of the Constitution to do something very dubious and take him off. And I think part of his message to his supporters is that he's being subject to unfair persecution, always has been since he was first elected with the FBI and so forth, and it's continuing. And as you said, that will just strengthen his appeal among the voters. It diminishes Trump's Republican rivals for the nomination because instead of talking about their ideas and their campaign, they have to talk about moves like we saw in Maine. And rightfully, they have defended him, but it's really an unfair kind of interference in the political process.
Kim, part of what is remarkable to me about this Maine ruling is that it is only 34 pages. And for that reason, it might be worth a read for listeners because it's relatively short, but goes through the series of legal issues that you need to answer against Trump in order to get to this conclusion. And a few of them are, is Section 3 self-executing? So is this provision of the Constitution barring insurrection is something that state officials like a Secretary of State can apply themselves without any further legislation or guidance from Congress? The Maine Secretary of State says yes. Does the disqualification provision cover Mr. Trump? Because there is a running debate happening in the public about whether this provision of the Constitution even applies to the presidency. The specific language of Section 3 of the 14th Amendment applies to officers of the United States and offices under the United States. And there are serious people, serious legal minds who say that those are terms of art that we get from English common law that refer to appointed officials, and that the President of the United States is not actually an officer of the United States or an office under the United States. The Maine Secretary of State obviously disagrees with that conclusion. Then we get to the merits of the January 6th issue. Was it an insurrection in the terms of the 14th Amendment? Would the people who framed that amendment after the Civil War, would they have recognized January 6th as an insurrection? And if you answer yes to that, then did Donald Trump engage in that insurrection? And that, I think, is an even more noteworthy point, because the way that she defines that, she says engaging in insurrection includes incitement of insurrection. So that's what she says she believes President Trump did in the run-up to January 6th and on January 6th. But Kim, part of what's remarkable about this is it's this daisy chain of legal propositions. And if a different court, the Supreme Court perhaps, answers any one of those in a different direction, then this does not apply to Donald Trump in the way that the Maine Secretary of State is insisting it does.
And that's what makes this entire ruling of hers remarkable. I mean, it was one thing, and in my mind, bad enough when the Colorado court ruled very narrowly 4-3, and even 3 of its own liberals on the court therefore dissented and made this decision to throw Trump off the ballot. Here we have an administrative ruling. This random elected Democratic official in the state of Maine issuing a decision that she is unilaterally going to delete Donald Trump from the primary ballot. And then in addition, we get this sort of breezy 34-page ruling that brings up, and in my mind, sort of quickly dismisses all these extremely weighty legal questions. And as you note, any one of those issues, is it self-executing? Does it apply to the presidency? Was it really an insurrection? Did Donald Trump actually engage in such insurrection? These are extremely weighty questions that, as the Colorado decision made clear, even people all who generally subscribe to the same judicial philosophy couldn't come to an agreement on. And there's a lot that would actually suggest that she got some of this wrong that's in the public record, meaning, and I'll just give one example, the special counsel, Jack Smith, who has obviously charged Donald Trump with a number of things, including mishandling documents and behavior related to January 6th, did not charge him with insurrection. And one of the reasons is because despite now years-long Department of Justice investigation into other participants in that day's events, there is no evidence that Donald Trump was communicating with anybody who was out there engaged in that riot or knew what was going to happen or knew the plans of the vanguard of some of those engaged in it. So the whole thing is pretty epic. Now, as she notes, this is going to be subject to a lower Maine court's decision, which has to come out within 20 days of her issuing her administrative ruling. And then there's another higher Maine court that it can be appealed to, and obviously the Supreme Court. And yes, I guess this is the way things are done in Maine, but it still is nonetheless, I think, concerning that one official felt she had the power to take such an unprecedented move all on her own.
And one thing I would underline is that skepticism of this legal argument on the 14th Amendment is not a defense of Trump or what happened on January 6th, which we have repeatedly said was awful, and the responsibility of Trump after he sold his supporters on this fantasy of a stolen election, called them to Washington on January 6th, and then directed them to marching toward the Capitol. And then what is perhaps the worst in my mind is the delay between when the riot started and any statement from him, any effort to get the Pentagon on the phone, to get federal agencies on the phone, to send aid to the besieged lawmakers at the Capitol. But it is notable that there are people who are not Trump fans who are making similar arguments. So there was an open letter from the Lieutenant Governor of California to the Secretary of State discussing this issue. And here is what the California Secretary of State said in response. Quote, removing a candidate from the ballot under Section 3 of the 14th Amendment is not something my office takes lightly and is not as simple as the requirement that a person be at least 35 years old to be president. And last week, when the California Secretary of State released the list of names that would appear on the ballot, Donald Trump was among them. So apparently a reluctance on the person in California who has a similar position to Maine's Shenna Bellows to take that step. And Bill, does this patchwork of decisions by these states, do you think, does it raise the odds that the Supreme Court will take this case? The Colorado one has already been appealed to the justices, and provide some finality on at least one of these questions that could answer the issue of whether the 14th Amendment applies to January 6th or President Trump and whether he's eligible to hold the presidency a second time.
Yes, absolutely. That's what the Supreme Court is for, to make clear what the Constitution stands for, especially when it involves the integrity of the election process. Remember that with all the writings of the Founding Fathers, one thing they really shared in common, they believed that most of these questions about the fitness of a candidate ought to be adjudicated by the voters themselves. I think they're going to throw it out. I mean, we already see from Colorado, as Kim points out, Maine, it was such a skimpier legal defense that one politician could do this, very activist politician, I might add, could do this. So I think the Supreme Court not only will, but it really has to. That's its obligation to restore some sanity. And I give credit. I mean, there are two reasons for Democrats not to like this. One, it's very dubious constitutionally. Two, as you mentioned, it's an in-kind contribution to Donald Trump. And if he gets elected, it's going to be because of games like this that they played. And they show no shyness about any institution that gets in the way, whether it's electoral college, the ballot. They'll just ride roughshod over it. So I think the court owes it. The sooner the better, because I think other states are planning similar things. The sooner or later they can nip it in the bud and lay out clear guidelines, the better off we all are.
Hang tight. We'll be right back with more on the 2024 race, Donald Trump and the Supreme Court in a moment. Welcome back. Since I mentioned the Iowa caucus a minute ago, let's check in on the polling there. Here is the Real Clear Politics average in the polling 2 weeks out from the caucus. Donald Trump, 51% of support. Ron DeSantis, about 19%. Nikki Haley, about 16%. And then Vivek Ramaswamy, 6%. And Kim, I agree with Bill that I think the odds are pretty good that the Supreme Court is going to answer this question once and for all. And I'm curious to see what that looks like, because I can only imagine that Chief Justice John Roberts would like to have a ruling that is not a 5-4 decision, not a 6-3 decision, something that if it's not unanimous, it's close to that. And so I wonder which of these issues might be conducive to that. If it will end up being a technical decision, something like whether the President of the United States is, in fact, an officer of the United States under the 14th Amendment, or perhaps not. Something that is unlikely to rile up the political partisans on either side, even as it does answer the question and take this decision about taking Trump off the ballots out of the hands of these 50 state Supreme Courts and 50 secretaries of state.
There's a lot there to work with. I mean, we named a few of the questions that Shenna Bellows addressed, which, I don't think were fully addressed and certainly didn't look at all sides of this issue. So, I mean, the court has a lot to go with. And I agree with you, Kyle, that I would wager that in this situation, more so than even other cases that the Chief Justice has dealt with, that there's going to be a very serious search to find a way in which he can get a 9-0 ruling. And what I really hope is that the three more liberal justices on the court work with him on that, because I think this is a very concerning state of events right now, where we have officials who it's clear there's a certain element of this that is about headline grabbing and attention seeking. And the very idea behind our Constitution is that we want some stability, and we're already watering down other aspects of this. For instance, impeachment. We've talked about this before on the show. I think that there's a concern that impeachment proceedings, which are supposed to be very grave, very solemn, used in only the most serious situations, are instead becoming a form of censure in the House, a way of slapping around a sitting president of an opposing party. And I'm concerned about that. Now we have this new Pandora's box of state courts or state officials, we now see, just coming up with situations in which they say, well, we're just going to throw off one political candidate from a ballot, in part because we don't like them. And again, not in any way to minimize what Trump does, but the bar needs to be quite high, because I can already quite easily see a scenario in which Republican officials or Republican courts in red states decide to use the same precedent to toss a Joe Biden off. And it doesn't take much to get to the place that Shenna Bellows got to in Maine from the other partisan side. So it would be very, very useful if the court sent a real brushback here and also along the way explained clearly the reasons for it so that we don't go there again lightly.
Bill, my last thought here is just that the Colorado Supreme Court's lengthy decision also seems to have given permission to other officials who are interested in this 14th Amendment argument, including Shenna Bellows. And if you read her administrative decision, it is remarkable how much it tracks the Colorado Supreme Court's ruling, cites it at times, relies on it. And so I think there's an impetus for the Supreme Court to act quickly, because otherwise you may see other secretaries of state who might have been wary of doing something so momentous on their own. I don't know how many of the secretaries of states of various states are lawyers. My presumption is that some of them are not, and that might have made them more wary to take this step without something like this Colorado Supreme Court decision that they can rely on and argue is the definitive answer to these legal questions.
Look, the danger of these unusual precedents is that they'll multiply and people come up with all sorts of novel readings. It's very easy to come up with a novel interpretation of the law that gets you where you want to go. I agree with Kim also. This will not be confined to the Democratic side. There'll be some reaction on the Republican side if it's allowed to stand. So it's really reckless. I mean, I think they're playing with a loaded gun. The Trump people are already, a lot of them at least, think the election last time was stolen from them. And when they see this sort of stuff, it confirms their beliefs. And you just think of the bad will and distrust that is sowing. And our democracy is not just based on the law. It's based on a little trust in the system. There'll be problems here and there, but overall kind of work. This is guaranteed to destroy that trust, any faith people have in it. And I think, as you point out, the justices not only have to do this, they have to do it quickly before we have a dozen of these type rulings, and it really gets out of hand.